Thank you all for joining us tonight. My name is Kate Kurera. I'm the Deputy Director at Environmental Advocates NY, New York State-based environmental advocacy organization based here in Albany. You're joining our session on unpacking New York State's Environmental Rights Amendment for municipal governments. I think as you mentioned, or we mentioned, if you're just joining, just please put your name and maybe your affiliation or local municipality that you're representing in the chat, and that would be great. And then maybe hold your questions and we'll do some question and answer at the end. So before I get into introducing the panelists that we have this evening, I just wanted to give a little bit of background on the Environmental Rights Amendment and how it became a right of our Constitution in New York State. So just wanted a little brief history, which I think is interesting because EANY in particular was integral in bringing the advocacy to get this right into our Constitution. So the story dates back to an impacted community in upstate New York called Hoosick Falls, who experienced and still experiences PFAS or PFOA in their water. In 2014, it was discovered in the drinking water supplies. EA and other advocates started helping that community come together and advocate for the state to respond to a cleanup and treatment. And of course, the advocacy, we sat in rooms with mothers and families who just asked the simple question, don't we have a right to drink clean water? At this similar time, there was a victory that occurred in Pennsylvania where a similar constitutional right had been revived in a state court decision where that right was being used to strike down a pro-fracking state law. So New York looked at the victory and the power of a constitutional amendment and began the process of advocating for something similar in New York. After many years of advocacy in the state legislature to get the amendment passed by two consecutive elected state legislatures, it was put before New Yorkers on the ballot in 2021, where 70% of voters voted yes for inserting this new and fundamental right. And if you haven't, you may have voted for it. And if you don't know, it reads, each person shall have a right to clean air, clean water, and a healthful environment. So now that this amendment is state law, constitutional law, this panel is going to help us unpack how this right interacts with our state laws, with our municipal laws, what municipal officials need to know to how to use it in decision-making and defending actions. So our first panelist is Maya Van Rossum, and she serves as the Delaware River Keeper and leader of the four-state organization Delaware River Keeper Network for 30 years. While she still serves in this role, in recent years, she's founded a national organization called Green Amendments for the Generations and authored two books titled The Green Amendment, all focused on advancing constitutional environmental right amendments that meet the definition of what Maya calls a Green Amendment. Her Green Amendment work is taking hold in over 15 states across the US. Our second panelist is Todd Ommen. He's New York. He's managing attorney at the Pace Environmental Litigation Clinic, as well as a professor of law at the Elizabeth Hub School of Law. He closely followed, studied, and advocated for the passage of New York's environmental rights, and now works on a team with environmental advocates and attorneys in New York to ensure the best implementation of this right and to educate members of the public and local governments on their rights and obligations. Our next panelist is Mark Freed, a lawyer of Pennsylvania, is also a partner at Curtin and Heefner with a focus on public sector law and environmental law in litigation. He's also a town supervisor at Different Township, Chester County, Pennsylvania, which he just told me that as we started. Mark has worked on and responsible for the strategic implementation of Pennsylvania's Green Amendment in a number of cases and assisted in promoting Green Amendment legislation across the country. Mark has also served 8 years as counsel with the Pennsylvania Department DEP, 2 years as a criminal prosecutor and in the Pennsylvania Attorney General's Office Environmental Crime Section. So that was a mouthful, but really excited to have this panel of guests to talk about this really important right in New York. And I say we get started. So I'm going to pose my first question to Maya, and just starting with the basics here. Can you first talk to us about what a Green Amendment is, or environmental rights amendment is, and what its characteristics are?
So thank you so much for that, Kate. I really appreciate it. And I appreciate the opportunity to lay that sort of foundational understanding for folks. Because a lot of people use the term Green Amendment and Environmental Rights Amendment sort of as though they're interchangeable, and they really are not when you look writ large. Now, New York's amendment in the Constitution is called the Environmental Rights Amendment. So it is the Environmental Rights Amendment of the New York Constitution. But when we're talking sort of bigger picture, every Green Amendment is an Environmental Rights Amendment, but not every Environmental Rights Amendment is a Green Amendment. There are key criteria that really have to be met in order to meet the definition of a Green Amendment. And how I came to identify these criteria was that I was actually the lead environmental plaintiff in that victory against that pro-fracking legislation that Kate mentioned. And in the wake of that victory, I went back and recognized what a powerful decision it was, and that we could not have accomplished what we accomplished absent the environmental rights language in the Pennsylvania Constitution. And so I looked at the Pennsylvania Constitution and I identified what really made it so powerful, what made it so special. I then looked at every constitution across the nation and found that at that time, only Montana had similar language that met these same criteria and really was also supporting powerful victories in that state. And so that's when I came upon the name, the Green Amendment. I wrote the book, The Green Amendment, and then founded Green Amendments for the Generations, and sort of vowed to help communities across the nation get this powerful protection everywhere. Now, what's a Green Amendment? There are a lot of must-have criteria, and there's some really great criteria, but I really just want to go through the must-haves. And New York's Environmental Rights Amendment, Article 1, Section 19, has all of these criteria, which is why it is a Green Amendment. The language must be in the Bill of Rights section of the Constitution. That is non-negotiable. That's where we recognize and protect all those other human, civil, and political rights we hold dear, those rights that get most powerful constitutional recognition and protection. If we want to get that most powerful constitutional recognition and protection for our environmental rights, we have to place the Green Amendment provision in the Bill of Rights section of the Constitution. The amendment must recognize the rights of all people to a clean, safe, and healthy environment. And it has to be clear about the rights that we're protecting essential fundamentals like water and air, a healthful environment. There are other constitutions that talk about environmental rights, but they talk about things like navigation, right? Which is fundamentally different. So we want to be clear that we're talking about these critical essentials to life, human health and ecological health. The language has to be self-executing, meaning it needs to be enforceable in its own right, that in the absence of implementing legislation, where there's a problem, people can turn directly to the language in the Constitution for an enforcement action. So that self-executing nature is really critical. And when we meet, and it must apply to all levels of government, from the local town council to the state legislature, right to the executive branch and the judiciary branch. And when we meet these kinds of criteria, what we literally do is lift up environmental rights so they are legally on par with those other fundamental rights. We all know how powerfully the right to free speech and freedom of religion are protected. If we want that same, we now with a constitutional Green Amendment, we get that same most powerful protection for our environmental rights. And I think that's sort of the long and the short of it. At this point, because of New York's edition of Article 1, Section 19, there are now 3 states with constitutional Green Amendments, Pennsylvania, Montana, and New York, but there are nearly a dozen other states that are pursuing such amendments at this time and are really being inspired by what is happening and has happened in New York.
Thanks so much, Maya. Yeah, so now that it's so interesting that there could be, the characteristics that have to be there and how New York has checked those boxes, which is great. And I know that when we were drafting the piece of legislation, that was really important to have all those considerations that, came up. So I guess now that we're here talking, hopefully to a lot of municipal governments and local officials, can you walk us through why it's so important that local officials understand? You already kind of touched on it applies to every level of government, but also what they need to be mindful of.
Yeah, and that really is very, very critical, is that local government officials have an independent obligation, and I would say an independent opportunity, right, to implement Article 1, Section 19 of the New York Constitution and make sure that all of their actions, activities, and decisions are protecting the environmental rights of their constituents. Of course, one municipality and one municipal official is not going to protect all clean water in the state of New York. That's not your obligation. Your obligation is to ensure that when you take actions that could impact the rights of the people identified in Article 1, Section 19, clean water and air and a healthful environment, that your action that you as a governing body are taking will not result in an infringement on those rights unless you can demonstrate that there's a compelling state interest, that the action you are taking directly serves that compelling state interest, and that you have done everything you can to minimize the level of infringement on the right. In the context of pollution and degradation, that means doing your best to minimize environmental pollution and degradation. Another obligation that comes from this constitutional entitlement of the people is that when you are engaged in decisions and government actions, you have to be very, very clear that you are not just implementing state laws and regulations and local ordinances that apply, but that you are also doing an independent consideration of the constitutional entitlement of the people and how your decision will impact that constitutional right. That independent investigation and assessment and making clear that you've done that consideration and made an appropriate determination are very, very important to demonstrating that you've fulfilled your constitutional obligation. Amongst the things that you will clearly want to do as part of that constitutional consideration is you want to engage in what we call informed decision-making. You want to make sure that you've considered, again, the impact of your decision on the constitutional entitlement. That means, are you looking at existing conditions on the ground? What will be the result of the cumulative impacts from your decision, both on its own, but in connection with other things that are already happening on the grounds? You want to look at relevant science and impacts, and you want to look at the environmental justice ramifications of your decision, because one of the benefits of Article 1, Section 19 is every person has the same constitutional entitlement. And so you as a government official must demonstrate that you are equitably protecting the environmental rights of all the people that will be impacted by your decisions and your decision making. I know that that's a lot, but I think that I'll just leave it there so we have space and time for more conversation, because I'm sure more about the obligations of local government officials will come up, but that's just sort of some broad strokes.
Great. Did anyone else want to add to that, or I have another, just going to move on. Okay. Yeah, I'm sure as we get into the questions. So I think what is on, at least on my mind, so since we've seen this amendment was incorporated into the Constitution last year, we have expected and should expect litigation to kind of flow from that and to be used. So I know that I'm familiar, and maybe others on this call or in the audience are familiar. There's one case in particular that's progressed, and now we have a small bit of judicial interpretation on the amendment. So I was hoping, Todd, maybe you could tell us a little bit about that case, which is the Fresh Air of East Side versus State of New York case, and explain how that amendment was interpreted in that decision, just noting that that was a judicial opinion on a motion to dismiss, and there are appeals, and it's not the complete deposition of the case, but it's giving us like a little, I guess, preview of one interpretation.
It does. It's the first substantive opinion we have in New York applying the right. So the context is there's a landfill upstate, and this landfill has a long, heavily documented history of odor problems and failure to comply with permit restrictions and other kind of environmental issues associated with the landfill. They were sued. The operator landfill was sued by a group of local residents. We'll call FAIF. It was Fresh Air for the East Side. Throughout the opinion, it's called FAIF. And they sued three entities. They sued the Waste Management, which was the operator. They sued the city of New York, and under the theory that the city of New York was the one sending all the waste up to the landfill, so they were the kind of the source of the problem. And they sued DEC under the theory that DEC was responsible for overseeing and enforcing against the operator. All claims based around the Green Amendment, right? So all claims based around this idea that this landfill is infringing on our local residents' life in terms of having a healthful environment, in terms of having clean air. And so all the entities that were named filed motions to dismiss. The court granted Waste Management's motion to dismiss, important to our discussion because Waste Management is a private entity, and the court found that you could not affirmatively assert a Green Amendment claim against a private entity, not a governmental entity. The court also dismissed New York City because New York City wasn't responsible for overseeing or permitting or enforcing against the landfill. New York City was just a customer essentially of the landfill. And so the court found that that wasn't a sufficient enough role to play here in causing the environmental issues. The real question for the Green Amendment was DEC. DEC's main argument was that these are enforcement decisions, right? Whether or not to bring an enforcement action against the landfill, how we're going to interpret and enforce our regulatory obligations in permitting the landfill. These are enforcement decisions, and we have discretion on how we're going to enforce. And so you can't bring an action to compel us to take any particular action because we have enforcement discretion. And if you're going to bring that type of action, you have to do it as what's called a mandamus action, an Article 78 mandamus action, which is, would ordinarily be found in challenging a specific final act of an agency. So the court rejected both of those somewhat related arguments. And basically, there's more to it than this, but for the purposes of this discussion, the court said you might have discretion in exactly how you go about your enforcement duties, but because this is a fundamental right, because this is a constitutional protection of the citizens, you certainly don't have the discretion to ignore it. You don't have the discretion to not respect this constitutional protection. And so what was called a declaratory judgment action, in other words, a claim seeking a ruling from the court that there is a constitutional violation here, was a proper way of remedying that. And that the injunctive relief sought, compelling DEC to take some action to remedy the environmental problems, was an appropriate remedy. And so the court denied DEC's motion to dismiss and held that the Green Amendment does provide for a cause of action to protect that constitutional right as against a state actor, where the state actor is either permitting or allowing or failing to stop some action that violates the constitutional rights of the local residents. And so that was the kind of the end result of where that case stands currently.
Thanks for that. Yeah, there are actually so many interesting layers to that, even just the dismissal against the private entity, because we've been saying that, even during debating this amendment through legislation, we would hear people say this applies to private entities, and just having some of that confirmation is really is interesting and helpful. So I was curious, Mark, if now we could jump to you and maybe talk about how this interpretation has compared or supported in Pennsylvania, where there's like a much larger, jurisprudence built up about the Green Amendment, mainly because it's been around for a lot longer and it's been litigated. So just curious how Pennsylvania courts have viewed the Green Amendment, and what are the seminal cases there?
Yeah, thank you. And I'm gonna focus on a couple aspects of the Green Amendment, but you touch on an interesting point, which is, our amendment, the Environmental Rights Amendment, also as it's known in Pennsylvania, has been around for a long time, but was, for all intents and purposes, a nullity for a very long time. It really wasn't until the Delaware River Keepers Robinson Township case in 2013, and that decision in 2013 breathed new life into it, that we really get sort of the modern jurisprudence and the developing of the modern jurisprudence. So I really begin, for the most part, with my analysis in 2013 and coming forward. But even with that, there is a good amount of case law that's been built up, a good amount of clarity that's been given, not just in Pennsylvania, but I think it it crosses boundaries and is applicable in many of the other states that have very similar language. So the Delaware Riverkeeper Robinson Township case was essentially, as you mentioned at the beginning, it was a dealt with pro-fracking legislation. The probably the most interesting part of that is in trying to push and allow fracking across the Commonwealth, they essentially, excuse me, the General Assembly essentially abrogated the local municipalities' right to zone when it came to fracking, which is pretty significant, given that one of the key elements of being a local government is your ability to handle your zoning, whether it's depending on the state you're in, whether it's at the county level or the municipal level. It's generally not at the state level. In Pennsylvania, it happens to be trickled down because we're a Commonwealth all the way down to the municipal level. So the upshot of that case, there were a couple important points that came out of that, which I think are particularly important for municipalities. Number one is that local governments have an express and implicit authority to address environmental issues, which cannot be abrogated by the state government. That was one of the key holdings, and it's a significant holding. And essentially what the court said in Robinson, which was a plurality, which was later affirmed by a majority in what has become known as the PEDF case, essentially said that all existing branches and levels of government derive constitutional duties and obligations with respect to the people. So there's often a desire on the part of municipal and local government actors, and I'm guilty of the same thing, say, well, we've got an expert, we've got an environmental agency that's an expert out there, let's just kick the ball over to them. Well, no, I mean, they have their realm, local governments have their realm, and within the local government realm, under the constitutional amendments, they have, and I like the way Maya put it, they have the opportunity as well as the duty to really look at the environmental issues within their context. The other important issue, and this will help me explain a little bit what things were like prior to 2013, is that the Environmental Rights Amendment is not coextensive with legislation. This is the piece that Maya said, that it's self-executing, which is so important to be a green amendment. For my entire tenure, and I started working for the state in the early 90s, went through into the early 2000s, for at least a decade before that and a decade after that, the view was the only thing that the government had to do in order to comply with the constitutional amendment was essentially, I mean, if you want to take the better view of it, you'd say, have to consider it when they're passing their laws. The reality is the only thing they really had to do was put in the findings of fact, or the purposes. The purpose of this statute is to implement Article 1, Section 27 of the Pennsylvania Constitution. Boom, we're done. Don't have to do anything else. And you've now satisfied the Constitution. And obviously, that was problematic. And so what would happen is, and you could probably find cases where I've made the argument and probably won on the argument, said, well, the Constitution has been implemented through the Solid Waste Management Act, many other statutes. I won't say the Clean Streams Law because that actually predates the amendment, but many statutes, and therefore there's nothing more we have to do. All they have to do is comply with the statute, and we're done. And that's the way it was until 2013, and when the Supreme Court said, wait a second, that doesn't make sense. And they came out with a standard that is, I believe, the appropriate standard. And it's the standard that you have now in New York with the self-executing language to indicate that the statute's self-executing. So, I don't want to take too much more time, but I think those 2 points are probably some of the key points that come out of some of the developing Pennsylvania jurisprudence.
Thanks for that, Mark. Yeah, there was a lot there. So I'm wondering, and I know you've mentioned tonight Montana as another place that had perhaps the first Green Amendment. If you could kind of like weave the pictures together and talk about examples of the cases brought in Montana and Pennsylvania where the Green Amendment, to give us some idea of like how it also might be used in New York, I guess.
So actually, Pennsylvania's Green Amendment came first. It just didn't get legal life until later. But thank you for that, Kate. There are a number of really interesting cases that have come forth, and I think just going through them very quickly gives people a sense of how these amendments have been used and what have been the outcomes. One of the things that I want to, and I'm going to sort of try to focus from the municipal perspective to the greatest degree possible. One of the most important things, though, to know about the Green Amendment legal challenges in Pennsylvania and Montana is that they have not only been brought, they are not only cases brought by individuals or environmental organizations like mine, actually municipalities and state government entities and actors have also relied upon the Green Amendment in various contexts in order to support their own authority to protect the environment or to defend themselves from actually having to implement a body of law that would be harmful to the environment and they felt was something they didn't want to do because it would actually infringe on the constitutional right. So I want to highlight that. And in the case that Mark highlighted, the Delaware Riverkeeper Network Robinson Township case focused on that pro-fracking law, the Delaware Riverkeeper Network was actually joined by 7 municipalities who were distressed because part of what was going on with the piece of state legislation that we were challenging was that the state had actually preempted local zoning authority when it came to the fracking industry. And so they actually could not zone where fracking could happen within their communities. And this law mandated that fracking be allowed to happen in every part of every community, including in the heart of the residential districts, with operating fracking well pads located as close as 300 feet from people's homes. And so in that Act 13 case, these 7 municipalities joined us in order to challenge, in part, that aspect of the law to say that the state law was infringing on the municipality's constitutional obligation and right to protect their local environment. There's another case where the state had passed a ban on plastic ban bills. For that, it said that municipalities couldn't put in place plastic ban bills, right? So it was a ban on plastic bag ban bills. And there, a number of municipalities brought a legal action to also challenge that law as an overreach and an infringement on the municipal authority to protect their environment through implementation of the Pennsylvania Green Amendment. That case never ultimately had to be brought. There are other reasons why that ban bill went away, but it just shows how municipal officials really feel empowered by having this constitutional obligation and entitlement to better protect their environment. We're also seeing municipal officials who want to render better decisions feeling empowered by the Green Amendment to do that. In Pennsylvania, there's a quickly urbanizing municipality outside of Philadelphia known as Municipal Township. And they had sort of a last big stand of natural open space. And it actually turned out that a very significant part of this open space was an old growth beech tree forest. That forest was being threatened by a development project. For a number of years, the community members advocated to protect the forest based on municipal ordinance, state law, but also their constitutional right to a healthy environment. When the municipal officials finally rendered their decision to reject the development, they very significantly, in the announcement of their determination, spoke about their constitutional obligation to protect the environmental rights and the natural resources of the state for present and future generations. And so they really grounded their decision in no small part upon that constitutional obligation. In Montana, there was a private deal between a developer and a purchaser that required the drinking of a test well for drinking water. And science came forth to show that if that test well had been drilled, that it would actually change the dynamics of the flow of the aquifer, and a pollution plume not too far away would actually be sucked into potentially the drinking water supply for an entire town, the entire town of Bozeman. In that case, the state actually did not want to enforce the obligation that existed to drill that test well. And so in no small part, relying on the Green Amendment, the state asked the court to defend them from having to enforce that test well drilling. And the court agreed, again, in part based on their constitutional obligation to protect the drinking water supplies, the water supplies of this town. We've seen industrial gold mining permits challenged because of their devastating consequences for the environment, but also because of a failure of government agencies to consider the science and the impacts and the cumulative impacts and the constitutional their constitutional obligations when they were rendering that permitting decision making. And in those cases where there was found to be a constitutional infringement, those permits were actually voided by the court. Now, the state could have come back and reissued the permits in a way that protected environmental rights and properly protected the environment, but they never did. So I think that tells us a lot. And then just one final example that I want to highlight is that in the Commonwealth of Pennsylvania as well, there was a situation where there was a highly toxic site in a supersaturated toxic condition for decades that the state agency knew about. There was existing law that required the state to hold responsible corporate entities accountable to clean up this toxic site, but the state for decades chose to do nothing. Instead, rather than secure cleanup of the site, they actually were giving a sweetheart deal to a developer to develop that site for over 200 residential homes while it remained in its toxic condition. This was a serious concern for the community as well as municipal officials. Community members along the Delaware Riverkeeper Network brought a challenge to say the failure of the government to act, that inaction to enforce the law and secure cleanup of the site to protect the environmental rights of the people and the natural resources of the state, that actually rose to being a constitutional violation. So inaction is action. And we saw that a little bit in the Faith case as well. Inaction by the state was also deemed to be action along with other actions that they had taken. So now the site is actually being cleaned up and the municipality is really happy because it's a very dangerous site. So those are just a few examples of how the amendment has been used and some of the outcomes where the municipality. Oh, and I do want to say there have been zoning challenges in the fracking context. And for the most part, actually, the municipalities' zoning ordinances have been upheld even in the face of a constitutional challenge, because they actually did do that very clear constitutional analysis, looking at impacts, cumulative impacts, science, environmental rights, and they were very clear that they considered the constitutional right and obligation, and they talked about how their decision, their zoning ordinance, actually honored the constitutional right and their obligation. And that was very persuasive to the courts in those particular cases.
Yeah, thanks, Maya. That was kind of my next question, like bringing it down a little bit to just like, how do municipalities actually go about discharging this duty, if you will, if that's how you want to call it, especially when we're, New York is a little bit different because we're unique and we have something called seeker, and so that adds a layer of environmental review onto government decisions or a certain level. So I'm hoping that maybe Todd, maybe you, and then Mark, you could jump in to talk a little bit about how municipalities can go about this and the intersection with some of our state environmental law.
Sure. Yeah. I mean, you mentioned seeker. So seeker is kind of the main, as far as municipalities, especially, and I'm sure I'm preaching to the choir here, but the main way in which municipalities address environmental concerns in making decisions. But there's a lot of important differences between seeker and the environmental right. So seeker is a creature of statute, but really also a creature of regulation. It's all laid out. There are boxes you have to check. There are things you have to do specifically. There are actions that require more seeker review. There are actions that do not require seeker review. So it's much more limited and much more spelled out exactly what has to be done. And if a developer falls within a certain category, then maybe no more seeker review or no seeker review has to be done, like a type 2 action. The constitutional protections aren't so limited. So even in a situation where a seeker review may not be triggered, if you have a type 2 action, if you have an action that doesn't otherwise require seeker review, that doesn't mean that you can just ignore any environmental concerns. I think we've all seen situations where an action might not trigger seeker, but yet has some environmental consequences, whether it be to water or air or otherwise. That's the kind of that's a situation where the environmental right has to be considered and ideally considered expressly. We have looked at the impacts of the environment. We have looked at how this will affect clean air or clean water or healthful environment. And, we feel it will not impact or conversely, maybe it will. So it's another layer of consideration that's not so constrained as seeker is, as far as exactly where it applies or exactly what has to be done step by step. It's an overarching duty. I like to think of it as an overarching duty to do no environmental harm, irrespective of what specific category or specific action we're talking about. And so it's something else to be considered in addition to seeker. Now, it may well be that a good, well done seeker analysis covers what you need to cover, but you need to be conscious of that. You have to, it's not a given. They're not coextensive by any stretch. And the environmental right is more overarching and more commonly applicable to any type of action that you might take, and something that should be considered. And frankly, even in that regard, it's also, if there's some situation where there is an applicant or a site plan that you feel maybe passes muster under seeker, but is so environmentally controversial or harmful that you don't want to approve it, it is also a tool in a municipality's disposal to reject that type of application, even if it wouldn't be mandated under seeker. It's another reason to look harder at the impacts and the consequences, even beyond the strict confines of what seeker requires. And all of those considerations, you're always best off documenting. We considered this, we looked at this, these are things that are implemented, and we considered this, and here's what we think the result is, and how we mitigated that, or how we dealt with that, or what conclusions we drew from that, so that whether it be the applicant challenging a rejection of a project or a citizen impacted challenging the approval of a project, you have shown that you've taken this into account and you've given it consideration. So I think that's kind of the overarch in terms of intersecting with seeker. I don't know if Mark wanted to add more nuance or detail to that.
Yeah, thank you. So I want to, and I like the fact that we're getting very practical, because I think that's helpful. To me, there's a number of ways to sort of implement the constitutional amendment. Two big ones are considering the constitutional amendment, considering the environmental issues in the decisions you make. So remember, the amendment is self-executing. So in and of itself, it provides the authority and the duty to consider environmental issues when you're making a decision. And the second important piece is that it provides a basis to pass ordinances, resolutions, other types of actions. Why is this important, particularly if it's self-executing? Why do you need it? I'm going to talk about two quick examples, one of which Maya's already touched on, and say how these things can play out differently. On the one hand, you have the Bishop Tube situation, which Maya was referencing, which is a situation of a highly contaminated site where the state had failed to take action for years. A developer came in with a residential development proposal, needed to go through land development. in order to get approval. The residents and Delaware Riverkeeper went to the township and essentially said, look, this is going to violate the environmental rights. It's not a good idea. And, you know, I believe that essentially the township was concerned that they might not be able to defend a denial. And so they ended up approving the development. So then right next door to this township is another township. In this other township, they actually have an ordinance that says you cannot get land development approval until you have a clean site. They essentially had an ordinance, they had legislation that required a clean site before you can do the development. Again, a developer came in on a highly contaminated site and said, we want to put a residential development here. However, because you have this ordinance that prevents us from doing it, we need a waiver. We don't just need you to approve this and we're going to say you failed to approve it and the judge is going to agree with us. We actually have to ask for a waiver from the law. We have to ask you to essentially lift the law that prevents us from developing this right now. And the township said, no, we're not comfortable with that. You follow the rules. And if and when you're able to follow the rules, we'll consider this, but for now it's denied. So you have two very different, two very similar factual situations with two very different legal setups, because in this other situation, the township and the municipality had taken the action to implement a law that essentially gave them the teeth and the power they needed to make sure that you weren't going to be putting residential developments on unclean sites. Again, it doesn't mean that in the other situation, in the Bishop Tube situation, the township couldn't have under the self-executing authority. This is the situation Maya was referring to in Marple Township, where the township acted to protect, the forests. Was a situation where they acted in large part on the self-executing nature. But what having an ordinance in place does is it empowers the municipality to essentially make the right action. So in a very practical way, it can really change the difference. And the other important thing here is to see that a municipality, a local government, has the power to act even where the state may choose not to act. And that can be a very powerful thing.
It's got me thinking. I think it's really interesting to highlight, the instances where the municipality is not just on the defensive, right, with this right, but actually using it as a tool, and as you've mentioned, to pass ordinances that are more environmentally protective. And I also thinking, New York is, I don't know the climate law situation in Pennsylvania, but in New York, we have a very aggressive Climate Leadership and Community Protection Act, which sets up a lot of mandates and targets for transitioning our economy off of fossil fuel. And I know that there are even, I think there's a local municipality here close to where we in Albany that have, even created an ordinance to not allow new gas station development, right? And whether, and I don't know if that's been challenged, but using the basis of the the constitutional amendment as a basis for making even more kind of pro-environmental outcomes, I think is interesting. So I guess the next thing I wanted to, and we're getting close to the top of hours, so we want to save some time for questions, but just one other question about kind of where DEC falls on all of this. I think, Todd, you already indicated, DEC had an argument in the case, the landfill case, that that their discretion was important. But do we have any other kind of sense of where DEC is, their thinking is about this? And then maybe like a follow-up would be for Mark and Maya, kind of, is this following a similar progression in other states that have had this right out a lot longer?
So we don't know exactly what DEC is going to do. I mean, on the plus side, in the Faith landfill case, while the city and Waste Management both argued that the right is not self-executing and requires legislation and regulation to be effective, DEC affirmatively did not make that argument. And the court noted that DEC did not make that argument, and the court rejected that argument anyway. We don't know exactly why DEC didn't make it, but it's good in a sense that they didn't. They acknowledge effectively that this is a self-executing right. Like I said earlier, they did make the argument that it doesn't impose any affirmative mandatory duties to take affirmative enforcement action, and the court rejected that. So whether they will continue to try and argue that, we don't know yet. They did start from that point of view, that this right, as great as it might be, doesn't require us to do anything affirmatively beyond what what we choose to do in our own discretion. And the court did reject that. So that argument, they might raise it again. We don't know. I can also tell you that there have been a few instances where DEC has had the opportunity to raise the Green Amendment affirmatively, but it has not done so. In particular, I'd highlight the Norlight situation. Norlight is a facility upstate that burns various types of waste, including some hazardous waste, and makes products out of that through that procedure. And neighbors have been complaining for decades. DEC has taken countless, like over a dozen enforcement actions against this entity, and recently filed a complaint, took the steps, not just an administrative enforcement action, but filed a complaint against the entity, and did not raise the Green Amendment as one of the bases for the complaint. Now, we sought to intervene on behalf of some local residents, trying to raise the Green Amendment in addition to, asserting regular claim or standard kind of tort law claims against the operator of Norlight. But there's that, and then DEC, as many people on the call might know, has also been rejecting some gas power plant applications for permits, situations where we thought the Green Amendment could be utilized, but they have not used that as a basis in those either. So that's a long way of saying we don't really know where they stand. We know they've taken some steps to push back initially, which were rejected in faith, but they have not yet come out with like a mission statement or an affirmative statement of where they feel, what they feel it means or how far they feel it goes.
And I think the thing to know about Pennsylvania is, first off, as Mark said, for the first 4 decades of the amendment's life, Pennsylvania was firmly, you comply with legislation and regulation, you're golden. And then when we had that transformational victory in December 2013, one would have thought that DEP would have now embraced the amendment as a great opportunity to do things better for the environment. But quite the opposite happened. I found myself in many a room and on many a panel where the DEP was, and other government officials was directly saying that nothing had changed based on that victory, even though there were other cases coming out. It was not self-executing. Legislation and regulation compliance is enough. And really very opposed to the strength and the legal life that the amendment now had. Slowly over time, we started to see more meaningful references to the amendment when agencies were taking action, or government officials, but yet DEP still on panels would be very resistant. And then about 1.5 years ago, I was on a legal panel where I was going to have a legal counsel from DEP on the panel as well. And I was fully prepared to have a great debate. And much to my wonderful surprise, she gave a presentation that I felt like I had written. All the most powerful points about the effectiveness of the amendment, inaction is action, self-executing, all of that. So DEP really has come around. It took about 8 or 9 years, right? But they did come around, and we are really now starting to see more embracing of the amendment. So it does, and I think, and that has come because every time there was a new case, there was more clarity on what the amendment meant, what the obligations of government officials were, and it started to become increasingly irrefutable that something had changed and that there was a clear obligation here. So I expect if we don't see quick embracing by DEC in New York State, that we will see it over time as more and more powerful precedents defending the right come forth, which is what I expect will happen.
Yeah, I mean, and that seems natural too, right? I mean, the words are very broad. We need some judicial interpretation for, I would imagine, the agency to feel comfortable. So I really appreciate we're at the top of the hour. I don't know if there are any questions from the panelists. I don't see too many questions in the chat. I see one comment from Chad that says Westchester County is working on a bill that would require an environmental review of any proposed new bills by members of the legislature, which strikes me as that's probably maybe not even necessary, a piece of legislation that might not be necessary in light of the amendment. Wasn't so much, I guess, a question as a comment.
There was in the Q&A, Bob Meek had an interesting question that I think I'm actually thinking maybe Todd might have some interesting thoughts on.
So I'm going to give a loyal answer. I don't know enough about the public trust doctrine to really give you a solid answer, nor do I want to try and be giving you legal advice over the Zoom. What I will say is that it's not at all the same thing. The public trust, and actually, frankly, Mark probably knows more, and Maya, you too, from Pennsylvania, about the public trust doctrine. So I'll let you talk more about the scope and of that. But this is different though, because this is an individual right held by individuals. And so when you as an individual, your environment is being negatively affected, regardless whether that portion of the environment is part of the public trust doctrine. Like, for example, the air is not part of the public trust. Healthful environment certainly is much broader than those areas traditionally covered by the public trust doctrine. So this is much broader. In this specific example in the question, it was a lake, so which is part of the public trust, but you wouldn't have the same enforcement rights. You wouldn't have the same protection as is provided by the environmental right. But I will defer to Maya and Mark to expand on the limitations of the public trust doctrine.
Mm-hmm.
And I'm going to let Maya do the cleanup because she's going to be the best to speak to it. The one point I want to make is that, one thing that came out of the Faith decision, and again, it's a important initial precedent that you have, is that there are certain aspects of, even though it's an individual right, that governments have to consider. When governments are making decisions, they have to consider those individual rights of making their decisions. So in that sense, I would say that the public trust doctrine and the individual right, although they're somewhat separate, it's a Venn diagram. There's an overlap. Yeah. And I do believe that, what you have in both doctrines is this opportunity. I love the way Mike said that. This opportunity and obligation to consider these things when you're making decisions.
I don't need to clean up anything. You guys did a good job.
And I have to apologize. I now see the Q&A is a separate chat. There are some questions in the chat and there's some in the Q&A. So I want to
I can talk about the Commerce Clause briefly. I'm not sure
Okay.
exactly what the question is. The Commerce Clause, if you're talking about the Federal Constitution Commerce Clause, that's what gives the federal government the authority to regulate certain areas when they involve interstate commerce. I think maybe the question is about the inverse Commerce Clause, where states are prevented from regulating things that would impede interstate commerce. But that's not the case here. States have always had a great deal of latitude in environmental regulation, and even more so, this is so not interstate commerce because this is an individual right. So I don't see any non-frivolous argument that somehow the inverse Commerce Clause limits this right. I can't imagine one. Another lawyer may be craftier than I, but I can't see how anybody's going to overturn a state constitutional right based on the Federal Commerce Clause.
Yeah, and it's an interesting question. I could see it, and actually, the one of the biggest cases, the two big cases in the Commerce Clause jurisprudence, one comes out of Philadelphia, New Jersey, and one comes out of New York, which is the Carbone case, which dealt with flow control in the 90s. And when you're and those are both waste cases. So depending on what you're dealing with, if you're dealing with commerce, you could have an argument, but I agree with Todd that it's not going to trump the individual right. And I will give you a historical example where there was an attempt to block an individual right with the Commerce Clause, and that was racial discrimination, and whether or not restaurants had to serve someone, traveling from Florida to Philadelphia. And not interesting enough, although he's not African American, my grandfather did get very dark in the summer and could not get served in Mississippi. But there was case law that essentially said, no, the Commerce Clause does not give you a right to infringe upon this individual. In fact, they used it the other way. They said, because you're traveling in interstate commerce, it's going to bolster the individual right. So, it potentially could have the exact, opposite effect. So, but it's an interesting question. I can't say I've really thought about all the aspects of it.
So there's a couple other questions here that I want to get to. So one question is a little bit broad, but I think it's a good one. It's like, okay, now what do I do? Like, where do local governments start with this information, or how do we process that? And then, well, let's start with that. And then there are at least two other ones which we can address after.
Well, sorry. So I'll throw something out. It is very broad. It's a hard question to answer. I would say, I think that the takeaway I have, what I want to give, I guess is a better way to say that, is it to be conscious of it, right? And that's where I would start. When you're making a decision, you're deciding to take an action, you're deciding to approve something, you're deciding to how you're going to evaluate something, be conscious of the way it impacts the environment, the way it impacts your residents that live in your municipality. And keep in mind that even if something like seeker or some other regulatory compliance is clear, that doesn't necessarily end the question of whether it's still something that needs to be approved, where it has negative adverse impacts. So I'd say be conscious of it and consider it, and document that consideration as you go forward. That's where I would start.
And I think the only thing that I would add to that is, thinking about that documentation of your considerations. First, state in your paperwork that there is this constitutional obligation, that it is self-executing, and that you as government officials have a duty to recognize and protect the rights. Then do look at what will be the individual impacts of your decision making, if it has to do with an individual facility or development project, or if you're looking at an ordinance and individual projects, look at the direct effects, look at cumulative impacts, look at whether or not, and document, as both Todd and Mark said, document all these decisions. Look at whether or not that ramification of your decision is going to result in a disproportionate impact to one part of the community versus others, to the level that it rises to an infringement of their environmental rights. Is there an environmental justice community that's already being impacted? What will be the ramifications? How will this exacerbate, help create an environmental justice issue? So I think and look at the science. That was one of the things that we had in one of the permit challenges we did in the Commonwealth of Pennsylvania. We were able to demonstrate that the municipality did not actually look at those impacts, cumulative impacts, relevant science that the community had brought forth that was directly on point, and yet the municipality was casting it aside and was not looking at it. They were just looking at the standards and the regulations. So look at all of these things, document it, listen to your residents when they talk to you about their Article 1, Section 19 Green Amendment rights. Include that in your mindfulness. That really is a very important place to start, and explain why you think the final outcome of your decision either serves or does not implicate the environmental rights in Article 1, Section 19, right? Like, speak directly to that part of your determination and decision making, and also recognize that even though you've considered all of these issues, if the outcome shows there's an implication for environmental rights, it's not like other laws where you have to just do an analysis and then you cannot think about it. You have to do an analysis, and if it shows a problem, you have to act upon it.
Yeah, and to follow up on that, it's funny, when a lot of the municipalities I represent, they always ask me to, the whereas clauses in your ordinances, the beginning of your ordinances mean anything. It's kind of a waste. Why do we even bother? And it really is the place where you can document the basis for your decision. And it really, particularly in a litigation situation, may become very important because it's going to be a contemporaneous evidence of what you were thinking when you passed the ordinance, or took the action, or did whatever it is that you're doing under the constitutional amendment. It can really make a difference in litigation.
Great, thanks for that. So a couple more questions, if you guys are still okay to sit on. So one question was just like, are there any other cases that are out there, using the right in addition to the landfill case?
There are a few where it's been raised. No decisions yet. There are a handful. There's one in Brooklyn, I believe. There's a few where people have raised the issue, but without having any public decisions or even really motion papers. They don't provide much guidance to you, and it wouldn't really be worth getting into, I don't think. And we sought, I think I mentioned this earlier, we've sought to raise it in the Norlight dispute, but the court has not yet ruled one way or the other whether we're allowed to come in and do that yet. So that'll be another decision shortly, hopefully.
The other thing I just want to add, in Pennsylvania and Montana, what we see in a lot of the cases, the majority of the cases, is that they are not cases based simply on the constitutional obligation and entitlement. They are cases that are about existing law, how they're being interpreted and applied, or like in the Bishop Tube case, whether or not they're being ignored. And then the Green Amendment is being brought in to help inform how that existing law should be interpreted, to demonstrate that the state government is interpreting it in a way that is so weak, or failing to implement it in a way that is resulting in a violation of the constitutional right, for example, or that they're not doing the appropriate analysis. But it's being brought in to inform the appropriate interpretation of existing laws, meaning that case was going to be brought anyway. But the environmental right is helping the courts and the people and the lawyers make the arguments and resolve, come to an ultimate resolution in terms of the judicial decision. And I expect to see that in New York too. There are going to be a lot more cases about how does Article 1, Section 19 inform how we should be interpreting, applying, enforcing existing law, rather than just freestanding constitutional. This is a violation of my constitutional right on its own.
Right. I mean, we've talked a lot about that over time, this is just what influences the better decision making, the better environmental outcomes, without the litigation necessarily. One other question, or a couple others. Does the violation of Section 19 give rise to a constitutional tort cause of action and potentially monetary damages? So, Todd, this is probably a good one for you.
Yeah, the answer is probably not, but I can't give you a definitive no, because New York courts, and including the Court of Appeals, the highest court in New York, have recognized in limited circumstances a constitutional tort for money damages. The one kind of key case in that was a stop and frisk situation. It's stop and frisk policy in New York violation was found to be violation of the constitutional right against illegal search and seizure. The court said because there's no remedy here, because these people were not being arrested, so there's no arrest to expunge, their rights are being continually violated with no alternative remedy. In that sort of situation, the court does allow for a tort if that's the only, money damages type tort, if that's the only remedy. Conceivably that could come up in the context of the environmental right. It would be an unusual situation because normally you'd be looking for a remedy of fixing the environmental problem, and so it's unlikely. But I couldn't rule it out. It really would be fact dependent.
And what we see in other cases are the portions of the law that are problematic are declared unconstitutional, so never enforced. The regulation is problematic, so not enforced. The permit results in a violation, and so the permit is voided. Right. These are in the failure of the state government to enforce the existing law to clean up the toxic site was deemed unconstitutional. The failure of Pennsylvania government to put in place drinking water protections from PFAS problematic under the Constitution and the right of the people there to pure water. So the remedies have all been about remedying the violation, and the court does not put itself into the shoes of the legislature or the regulator or the local town council and say, okay, there's a constitutional violation. This is how you remedy it. No, they say there's a constitutional violation. The government entity responsible for creating that violation now has to figure out what the next steps will be. Either the unconstitutional law, permit, etc., are just left unenforced, right? Because they're unconstitutional, they're removed. Or in the case of like a permit, I mean, they can go back and reissue the permit and try to remedy the constitutional infirmity. Often what we see is they actually don't do that, which shows me that, they couldn't have.
Great, thanks for that. I see one last question here. Is about kind of like, do we have a template? We've talked about kind of what this sounds like. So the actual question is, do you have a concise write-up of a local government duty under the Green Amendment, and that we could use to arm local officials with maybe included lists of questions, considerations for legislation, program, project approvals, etc.?
Mm-hmm. So I'm going to just say at this point, we don't. Early on in the Commonwealth of Pennsylvania, when we had a few early decisions, we did write up that kind of document, but that's because the way those decisions were coming out, they offered some really helpful clarity. New York's amendment is very fresh, is very new. We only have one decision. So we are offering our best guidance based on constitutional law, principles of law in general, as well as what we are seeing in Montana and Pennsylvania. At this point, we don't have that kind of document, although I do have on the forthegenerations.org website a lot of fact sheets and a lot of frequently asked questions that I think do explore some of these issues. But I will take that suggestion back and I will go to my partners at EANY, Environmental Advocates of New York, and other partners, and we will give careful consideration to that request and express need.
Yeah, the one very practical sort of roadmap I would give you is when you're taking an action, whether it's an action to approve or deny an application, whether it's passing an ordinance, making a resolution, rely not just on the Environmental Rights Amendment, but also on the other basis of law. Cover everything. This is what we do in Pennsylvania. In Pennsylvania, for instance, we have what we call second-class township. So we have the second-class township code. When we're passing something, we say, okay, this is our authority under the second-class township code. This is our authority under other statutes, and this is our authority under the Environmental Rights Amendment. We put them all in, to sort of make a big soup of our authority that includes the Environmental Rights Amendment, but also includes a lot of other things. And it's a bit of a hedge if for some reason you end up in a court that doesn't see the Environmental Rights Amendment the way I'll say that maybe they should. You still have other bases to support your action. Great,
thanks so much. So I think, we've come to a good closing point. The only other thing I would add for helpful resources, and maybe we'll follow up to registrants after, is that I think Pace University too has their, I'll throw that in the chat, that their environmental rights law, their site that they've compiled like the cases and the history and some other useful information. So I've just posted that in the chat, but we could add that to any follow-up.
And someone was asking for a copy of that decision. We were talking about the FAIF decision. That's there. That's the place you can get it.
Yep. Sounds great. Well, I really appreciate your time on I don't even know what day of the week it is anymore, Thursday?
Still Thursday. We didn't go 5 hours over.
Yeah. And I'm with you, Todd. I have a little one also asking, where's dinner and bedtime. So I appreciate Maya working with you again on this, and nice to hear your contributions, Mark. And I hope everyone has a great night.
Bye, everybody.